Welcome to Then and Now, a podcast by the UCLA Luskin Center for History and Policy. We study change in order to make change, linking knowledge of the past to the quest for a better future. Every other week, we examine the most pressing issues of the day through a historical lens, helping us understand what happened then and what that means for us now.
Welcome to Then and Now. I'm David Myers, director of the UCLA Luskin Center for History and Policy, which hosts this podcast. I'm pleased to welcome to this episode Professor Anna Spain Bradley, who is a member of the faculty of the UCLA Law School and also serves as Vice Chancellor for Equity, Diversity, and Inclusion at UCLA. On another occasion, I look forward to speaking to her about her work in EDI at UCLA. But today we'll be talking to Professor Bradley about her scholarly expertise in the field of international law. And I want to emphasize that she will not be speaking here today in her capacity as Vice Chancellor for Equity, Diversity, and Inclusion. So international law has been an urgent topic of conversation since the Russian invasion of Ukraine on February 24th, 2022. Indeed, the question arises as a result of the invasion of what the meaning of international law is. When is war legitimate? What means of war are legal and which means are illegal? What constitutes war crimes? And when is it necessary to describe a massive attack as genocide? Some are skeptical of the very premise of international law. For example, in a recent op-ed in the New York Times, columnist Ross Douthat argued that, and here I quote, "The idea of a law-bound, process-driven international approach to genocide or any war crime was always just a fantasy." To help us make sense of that claim and the larger domain of international law, we're delighted to have Professor Bradley with us. She is the author of Human Choice in International Law, published by Cambridge University Press in 2021, together with Mary Ellen O'Connell and Amy Cohen, International Dispute Resolution, from Carolina Academic Press, 2021, and the forthcoming book, Global Racism, from Oxford University. Welcome to Then and Now, Anna.
Hello, David. It's great to be here with you today.
Great. So let's jump right in. The aftermath of the Second World War witnessed a very significant expansion of the edifice of international law, beginning with the definition of the crime of genocide in the 1948 Genocide Convention and of war crimes in the Geneva Convention of 1949. Can you help us understand the motivation behind these new international legal norms?
It's a great question. I think we know that World War II changed the world. I mean, most of us have family members that were affected by this global war, and those effects lasted long beyond the war itself. But one aspect of this was the formalization of international law. The legal system that existed prior to the war was built on this idea of the law of nations, where certain and only certain nations were invited into a club, largely in Europe, to abide by certain norms and practices when dealing with one another, but not, for example, when dealing with peoples throughout Asia, Africa, and Latin America. World War II took this nascent system and deepened it and widened it to become a global framework built on what we now call the international order. And in the international order, we have international law and institutions. We also have politics. Political aspects of this order are paramount. But I think what we can say did change is the realization from the war that we live in one world. And if we're going to live in one world, we have to be coordinated. International law and its tools allow that kind of coordination, allow for multilateralism, cooperation, and allow for nations to avoid a future world war by having means to talk and communicate and trade and ultimately resolve disputes peacefully.
Right. Obviously, the United Nations would be one very important foundation in that edifice of international law. That leads me to the question, though, how is international law enforced? Because the principle would seem to be quite different from the means of enforcement of the law of a sovereign nation state, what may have existed prior to that point, prior to the Second World War, and that global term that you described. So what's the underlying theory, and for that matter, praxis of the enforcement of international law, which is built on consensus rather than coercive means that a nation state may impose upon its citizens?
Well, the shorter answer is there is no one theory. There are many, and this is a source of interesting conversation and indeed argumentation in the field of international law. But I like the way that former International Court of Justice President Dame Rosalind Higgins put it. And she once said, quote, "International law is a set of rules, a legal system with norms, and the result of decision-making processes," end quote. I think ultimately international law works in at least two ways that you and I can understand, akin to our experience in a local city or state. The first way is that policing power. When somebody runs the red light, if you get caught, you get a ticket, and then you have to pay or take traffic school. In international law, the policing power is very specific and narrow. And it's something that we'll be talking about, I've gathered today, as we think about world events. It's the Security Council of the United Nations that has the authorized police power under very specific circumstances to say that it's legal to use force in order to maintain international peace and security. But most of international law is not working on a police power. It's working on a club. You want to be a part of the club, in this case of trade, in order to profit from the benefits afforded to members of the club. And if you're going to be in the club, you have to follow the rules. So if you don't follow the rules, you get kicked out of the club. This kind of self-enforcement mechanism is much of what international law relies on. And it all goes back to the origin. It didn't have to be this way. There's a wonderful book that I recommend always by Hans Kelsen, written during the war and published in 1944, called Peace Through Law. If we had a world government structure with a strong top-down enforcement mechanism, it would be a very different world. And for some of us, we think that could be good. And for others, we think that would be a nightmare. But that's a model that we have in certain countries that we don't have in the international field.
Right. So just thinking of the policing element of international law, leaving aside the more consensual club-based principle, you mentioned the United Nations Security Council. That is one means of policing. There also are at least two legal bodies that I know about, and I'm sure there are many more, that would seem to play some role in terms of the policing function. I'm thinking of the International Court of Justice, which arose, I believe, just after the end of the Second World War, and the International Criminal Court, which came much later. Can you speak about their functions and the Security Council as well as part of that sort of more coercive side of the equation in terms of the enforcement of international law? And how would you rate their performance over time? I'm curious at some point to get your sense as an international lawyer, how's it working? But maybe we'll begin with just the Security Council and these legal bodies that have been set up.
So, David, we'll start with the how is it supposed to work? And then I look forward to talking with you about my opinion and assessment of how it's working. So I wrote about much of this in my book on human choice in international law. And you can't understand international law without understanding history, because so much about the way things are today has everything to do with the way things were. And so I just want to give a little brief origin story of the International Court of Justice, which I love. In the 17 and 1800s, we had a nascent collection of nations trying to cooperate, mostly around marine-based trade. So if you were an entity that had ships, marine ships, and you could do shipping, you had the mechanism for extreme wealth. Now, what was being shipped back then? Cotton, raw goods, manufactured goods, and people. The transatlantic slave trade was the economic machinery of its day. So when we think about the way in which fortunes were made and rules were based, it has everything to do with the history of slavery and the slave trade more specifically. And herein, there were big, expensive arguments. A Dutch ship docks in a French port in the West Indies and was sunk in retribution. Who should pay? Territory discovered by Portuguese was claimed by Prussia. Who gets to govern it? All of these disputes went to early versions of courts. They were known as arbitration tribunals of their day. And so by the time we get to 1899, and Europe is once again on the brink of widespread war, then Tsar Nicholas II of Russia uses this as a political opportunity to invite certain nations to create an agreement. And it resulted in what we now know to be the Hague Peace Conference of 1899. He then helped fund the building of the Peace Palace in The Hague with beautiful swans swimming in the lakes behind it. And in 1913, we get our very first permanent court of arbitration. That became the grounding foundation for the idea of an international court. Later, during the League of Nations, we get the Permanent Court of Justice. The difference between the two, the Permanent Court of Arbitration did not have sitting judges. The Permanent Court of Justice did. That was disbanded, but then after World War II, it became the International Court of Justice. So since 1945 and established by all nations in the United Nations Charter, we have a world court with jurisdiction to cover subject matter disputes that can be, quote, resolved on the basis of international law between nations. This is important because where in world history have we had the idea and the creation of a court with this kind of reach? So is it perfect today? How's it doing? There's a lot on that. And many more people, including myself, have had debates and written responses to this question. But I think the ICJ is really special for the fact that it exists. It has resolved numerous disputes between nations since its inception. And in a parallel data world, if we look at the incidents of armed conflict between nations since 1945, it's gone down to almost zero until most recently, Russia has illegally invaded Ukraine. So the ICJ is not perfect, and no institution is, but it has served an important practical and symbolic purpose. So that's the ICJ story. The Rome Statute and the International Criminal Court is a more complicated one, so I'm going to let you ask about that if we want to go in that direction.
Great. Let's talk about that. So we have alongside the International Court of Justice, the International Criminal Court. As I understand, the ICJ deals with nations and the ICC with individuals. Is that the distinction of relevance?
Yes. So the ICC was set up in a different way, and its jurisdiction is around what we call international crimes associated with war. And the perpetrator is an individual. So you're looking for one person or multiple individuals who committed a crime under international criminal law.
Right. And the International Criminal Court was an outgrowth of something called the Rome Statute, which sort of was worked on, I think, from 1998 to the early 2000s. And interestingly, the United States is not a signatory to the Rome Statute. I believe just, to sort of bring our conversation to where we're ultimately heading, Russia was a signatory, but no longer is. Was a signatory, may not have ratified, but no longer is. So I'm wondering, given that consensual nature of international law, what's the significance of the fact that you have something like the Rome Statute, the International Criminal Court established in its wake, and a number of major world powers not signing on to it?
It is an essential question, particularly relevant for what's going on in the world today. But history. So long before World War I and World War II, we had armed conflicts, horrible armed conflicts, where not only was the outcome of the war devastating for civilians, notably for children, often for women, but the way in which people went to war used to be called absolute war. Do anything it takes to win. And in the late 1800s, we start to convene around the idea that this way of going to war is so inhumane that we need to have ways to have a different model. So after World War II, of course, famously, we set up the Nuremberg trials, which were imperfect in their procedure, but were necessary in the moment to figure out what to do. And from there, we set up these ad hoc tribunals, the ad hoc tribunal in Yugoslavia and other ad hoc tribunals. It's very expensive and it's very slow. So the idea behind the Rome Statute, which is a treaty, was that nations would agree, much like they did on the establishment of the International Court of Justice through the United Nations Charter, they would agree by the treaty, the Rome Statute, to set up a permanent standing international criminal court that could always function, that would have judges and officials with deep expertise, that was on standby should there be a need to prosecute people for alleged international crimes. But in the treaty process, like many treaty processes, lots of nations don't always agree to the terms. And the United States although it was on record of supporting the idea, took issue with certain aspects of the treaty. And, many have argued really just didn't want to be under the power of international law. In the United States, as you well know, and many of our listeners appreciate, treaties have to usually be ratified by our Congress. And if you were going to get Congress to ratify treaty giving power away from the United States to be under an international body, that is a political act that is not easy to achieve. So for many political reasons, the United States did not ratify the Rome Statute, but did commit to abiding by the purpose, i.e. prosecuting international crimes through our local court system. And that sent a signal. Lots of other countries said, well, if the US doesn't have to ratify, we don't either, or we're not going to. And, from a political standpoint, we see the weakening of this idea. We don't have a court today like we do with the ICJ that has global reach because a lot of countries are non-participatory.
So just in terms of United States' own position as a promoter of human rights and adherence to international legal norms, as certainly many officials and elected and otherwise claim to do, the failure to sign the Rome Statute or by consequence accept the authority of the International Criminal Court would seem to undermine the very principle of international law. And it's for understandable reasons, I would assume, the United States does not itself want to be subject to the norms of the Rome Statute. It doesn't want its officials to be called before the International Criminal Court, especially when allegations of war crimes arise. So how significant is this for the project of international law, given that you earlier said, there's been a lot of success, especially associated with the ICJ? This would seem to the uninformed observer to be a very significant factor in the enforcement and upholding of international law that the most powerful country in the world selectively joins.
It's a great question, and it makes me reflect on my early career. I started working in international law spaces and in government in America in the 90s, and I was a small, teeny player on the Conference of the Parties 6 with the Framework Agreement on Climate Change. And I remember back in the 90s, there was a lot of sense around the world that the United States was a champion of international law, of human rights, of peace and security. And then, through our own country's actions and inactions, people started to be much more critical. Actually, does the United States serve the purpose of international law, peace, security, and human rights, or does it serve its own national interests, whatever those may be in any particular administration? And this is where we have to be thoughtful about law, politics, and the interactions between. All law is political. People are political. People make the law ultimately, and what we do with it as a tool, how we use it to serve higher aims, is ultimately up to all of us, channeled, of course, through governments and through representative leaders, and in some countries through non-representative leaders. So when we're critiquing the tool of international law or any other tool, we're also being self-critical. And I think it is absolutely the case in 2020, in light of all that's happened in the world, that people are suspicious, and rightly so, of America's intentions in the world and many other countries, because we have moved away from a sense of collective obligation, what we owe to the world as a whole, in favor often of individual rights, what I need or what my group or my country or my kind needs. And at the end of the day, we are a collective. We share one planet. With climate change and the climate crisis, we're ever more aware and reminded of that. And we need to use the tools that international law and other groups afford us to serve collective aims. So speaking specifically about the Rome Statute, crimes happen in all wars, which is why preventing the war itself, armed conflict itself, must be paramount. Once crimes do happen, we have a series of tools for understanding and separating what kind of action is that and what kind of a crime is that and what should happen to those who have been proven to have committed those crimes under international criminal law. And the Rome Statute set up and captured frameworks from earlier treaties and also from norms and values and customary law in one fell swoop. So even though the court itself doesn't have the participation of all nations, you can look at the project of the Rome Statute as setting the world on notice about collective wrongs that we all agree should be avoided. We just don't agree on who gets to decide. Who gets to decide if they have happened or not, and what kinds of courts get to prosecute them. But that first underlying framework to say there is such a thing as an international crime, there is such a thing as decrying that no matter where you are in the world. That genocide, for example, is always wrong and should always be prevented or prosecuted. That's important, and we shouldn't lose sight of that.
You suggest that there's, at some level, lesser commitment to the collective project of international law and more of a commitment to an individual group's rights or an individual nation's rights. And I'm wondering if you can help us, since we are a podcast that pays a lot of attention to history, which you have gratefully indulged us in. How would you describe the swing of the pendulum? So in the aftermath of the Second World War, there's a great passion for strong bodies and principles of enforcement of this new project of international law. I'm wondering, as you describe it, if the Rome Statute ironically marks sort of the end of that era of robust commitment to the collectivism of international law, because it engenders all sorts of controversies and fears of individual state actors being summoned to the ICC. But I'm curious, when do you think that robust commitment to collectivism began to wane? We certainly have passed in the last decade through a period of illiberal democracy, as Viktor Orban famously or infamously called it, but I assume that the waning began before then. How would you periodize it?
David, it's such a thoughtful question, and it's something that all of our listeners, I'm sure, can and will weigh in on their own, because we're living through this. I think we know from historical data there's a strong correlation between times of crisis, whether that's a war, a global pandemic, a global depression, or other conditions, and a spillover effect after that to people voting for strong, often autocratic rulers, moving away from democratic forms of governance into autocratic ones. So we saw this after the 1918 pandemic and after World War I and after World War II, the swing towards fascism, the swing towards totalitarianism and other forms of governance structures that politicized a story for voters or for people that somebody was in charge, someone was all powerful, and if only you believed in that person, often in history it's been men, you too could be saved. And part of that story is then there are others who are not as good as you, others who don't deserve to be where you are. And if you follow the ruler, they will lift you up and away from the undesirables, which gets us back into the topic of where do we see the origins of international crimes in the first place? We start to see it in societies where there are groups of people, my kind and your kind, and certain kinds aren't valued under the law or under practice. Certain kinds are believed to be less than human. And those kinds of conditions are very, very dangerous for everyone. So I think back to where does this start? In many ways, we can see that it starts with times of crises and the after effects of people processing what they've lived through or what they have survived and making often deep human choices about where they feel safe. And those are politicized. Those are used for political aims and for power-based aims. So the rule of law, which we've been with for a couple of hundreds of years in many ways, is always up against the recourse to the power of often men and now increasingly women. So rule of law needs to be a check on power, because the recourse to use power towards aims that hurt masses of people has always been a part of our human history. And law is one of the tools that helps us move away from that.
So I want to turn to Russia in just a minute, but I have one more large question to ask you, which has intrigued me for some time and certainly intrigued many. And that is this whole edifice that you have described, and for that matter, the idea of international law, basically a Western project, a project of Europe and the United States, and not of the developing world? How would you address that criticism labeled against the project of international law?
I appreciate the question. And for all the ways this podcast, I've been saying, let's look at the past. I'm going to ask all of us now to think about the future. How do we build the international law we need? And to think about the future, we need to have a critical lens. As I've said all along, international law is a set of tools. It's a set of tools that can be used for positive and negative aims. And it's up to the users of the tools to use the tools to achieve the right aims. So what are the right aims? I have a very critical lens as a scholar of international law, as a professor and educator in this field, of teaching people the whole story. And so is it true that what we most commonly understand international law to be today to have been created solely by Western and European nations? No. There have been lots of innovations in international law that come from other places and cultures and parts of the world. Those stories just haven't been as promoted, but they're there. And more scholars and writers and researchers are telling those stories. Has it been true that the powerful nations of the world in recent history have been largely European and Western? Yes. And those powerful nations have used these tools to their aims, and we can critique that. So I think the international law of the future is becoming globally diverse because many groups around the world are seeing ways that they can use these tools too. And they're putting them to good use and sometimes to harmful use. But it's an important moment in the field of international law in the past several years where down to how it's being taught and understood, down to how the history is being retold from a more global and equitable perspective, we're fully realizing all that international law always was and all that it might be for all of us.
Okay, let's turn to a contemporary case study in international law, Russia's invasion of Ukraine. It has been widely regarded as illegal. And my question to you is, what makes for the determination of legality or illegality? What makes for a legal use of force or a legal declaration of war according to international law?
So as a former international law attorney and as a current international law scholar, I can say that Russia's invasion into Ukraine is illegal. Russia's invasion into Ukraine is prohibited under international law. Here we look at the United Nations Charter, which is our ruling document that governs all nations. All 196 nations in the world are party to the United Nations Charter and have agreed to be bound by its terms, Russia included. So Article 2.4 of that charter prohibits the threat or the use of force against the territorial integrity or political independence of any state. Russia's actions constitute a violation of 2.4. There are only two exceptions where such a violation is permissible. One is self-defense, Article 51 of the Charter. I have yet to see any convincing argument that Russia's actions could fall within a self-defense exception. And the second would be if the UN Security Council, under its Chapter 7 authority, voted to use force in another nation for purposes of maintaining peace and security. This force was not UN Security Council authorized. So on those grounds, it's clear this is an illegal use of force. It's also, under the Rome Statute, Article 8, a crime of aggression by one nation aggressing against another. So any way you look at the law here, this is one of the clearest and most direct violations of international law, and Russia has been put on notice by many an international body about this.
So do you think the United States is being duplicitous or hypocritical because previous military actions that it undertook might have been deemed to be illegal, like the invasion of Iraq or the decision to go into Bosnia? How do you respond to that claim with respect to the United States' stance on Russia?
So I'm always cautious to avoid false dichotomies, like is this like that, or is, when really we have to assess each and every incident on its own merits. So this is the lawyer in me. At the United Nations level, it's for the United Nations to make the determination if the charter has been violated. And there's a number of different mechanisms that we've kind of talked about some of them for doing that. So one country doesn't get to say unilaterally, the other country is in violation of international law. International legal frameworks and institutions get to say that. And they've said that here. But back to the United States, have we as a country done things that have been in violation of international law? Yes, absolutely. It's on record. Our activities, such as they were in Nicaragua, went to the International Court of Justice, and the ICJ determined that the United States had violated international law and the UN Charter in those actions. So I think what the interesting case is the invasion into Iraq. And there was so much talk of weapons of mass destruction and other sorts of things. Why? If the United States didn't care about international law at all, why go through the trouble of trying to scrounge up a self-defense exception? So one way that we've commonly read this is the United States was going to do what it was going to do, but it wanted to look at that time under that administration like it was at least nodding to the UN Charter, saying, we know we're using force, but we're under Article 51 self-defense exception, even if later that was deemed to be wrong. Russia, the moment that Russia launched its invasion into Ukraine, was the same evening that the United Nations Security Council was meeting on the issue of Russia and Ukraine. So not only did it not try to scrounge up a self-defense exception, and I'm not saying that that's a good thing, but it was a giant slap in the face of the United Nations. Literally, the moment the Russian ambassador was making a statement on the floor, short minutes after that, news reported the first aerial attacks into Ukraine.
So ironically, Colin Powell's infamous appearance at the United Nations Security Council attests to the commitment of the United States, in some sense, to the principles of international law. And we don't see anything comparable present in the case of Russia. So you have said that from your perspective as international lawyer and scholar, Russia's invasion of Ukraine is clearly illegal. Are you also paying attention to whether Russia has committed war crimes and perhaps is engaged in genocide?
Yeah, so everyone's paying attention to this, and it's so tragic to know it's happening right now, this very moment. And so many of us who feel deep care and concern also feel utterly helpless to help in this exact moment. So first, let's just go back to how do we understand what a war crime is? And the Rome Statute codifies this, because prior to that, we had customary law and different historical perspectives, but we can understand that a war crime happens during times of war. And depending on the kinds of actions, there are categories. It used to be crimes against peace, crimes against humanity, war crimes, and genocide. And then crimes against peace kind of went to the wayside. If you have something happening and it's not during a wartime, you can still prosecute it under crimes of humanity. But war crimes often attach to what a individual is doing in war. Are you as an individual engaging in torture? Are you as an individual taking a prisoner of war and not treating them fairly and not affording them a fair trial? Are you as an individual engaging children to wage war? Are you using weapons that have been outlawed and banned? Are you targeting civilian targets that have no possible justification in the military approach just for purpose of demoralizing or dehumanizing people? These are all the kinds of activities that take place and have taken place during war that are later prosecuted for being in violation of various aspects of international criminal law. The big one is genocide, and I want to take a moment to talk about why it's the big one. Genocide is a war crime, but genocide is also something more. And this goes back to history again. The world has long agreed that certain things shall not be done. They're called Latin jus cogens. They are considered to be norms that nations can't derogate from. You don't have to have a treaty. You don't have to agree. These are the things that, and there's a very small category, that are so egregious to the project of being a human civilization in the world that they're agreed upon to be not tolerated. Genocide is one of those jus cogens. And because of the insidious nature of genocide, it's not just a crime that kills and harms and rapes and traumatizes millions of people. It's a crime with a specific intent requirement, that the people engaging in the acts are doing so with a specific purpose and intent to eradicate an entire group of people on the basis of their identity. And for that reason, it's so harmful that it can never be allowed. Now, genocide has happened. And is genocide happening right now in Ukraine? We have lots of evidence to suggest that we need to evaluate it. We need to investigate it. And that's precisely what certain international mechanisms are doing. And the evidence will come forward. But it's really hard to prove specific intent. And when we look about Darfur and other examples in recent history, you have to usually find documentation by the government or by military forces saying why they're doing the attack, saying that they're trying to get rid of a group of people because they are a group of people. And preserving that kind of evidence is hard in the middle of a war.
In order to establish intent.
Exactly.
That being a key criterion of genocide.
Exactly.
What are the mechanisms? What is the process? What will happen here in the case of Russia-Ukraine? Who will investigate whether war crimes have taken place? Who will inquire into whether genocide has been committed?
Well, I wish I had a crystal ball to say what will happen here. I think we should be asking our governments and our United Nations groups what can happen, what mechanisms are we employing, which ones haven't we employed yet. So there are many. We have talked about a few. We've talked about the International Court of Justice. There's action before that group. We've talked about the International Criminal Court. There's action before that group. We've talked about the UN Security Council, which is has a challenge because Russia is a permanent member and has a veto. But there's work in the UN General Assembly, and they recently launched the rare Uniting for Peace mechanism to try to make a statement against the veto by Russia in the Security Council. So there's all these sort of machinations in each part of the international structure doing what they can. At the end of the day, when you have a war like this, an illegal invasion, an act of aggression, I think it always comes down to who's making the decision. Is it Vladimir Putin? Is it him plus others? Are there actors we're unaware of, at least we in the public? And what would change the decision makers' minds? What would make them choose to stop? What would make them choose to retreat, to give up the territory they've already gained? What can do that? And this is something I get into in my book at Human Choice International Law. Until we understand that layer of decision making, a lot of our mechanisms might not reach the desired outcome. I think we're all wondering, do you use force to stop force? Do you go to war to stop a war? And that's the question that this horrific invasion has brought the world to once again.
Do you have a view on that?
In short term, I guess I'll leave it at this, that I believe in peace. Since I'm 15 years old, I've been working in some form or fashion in the field of peace. It's been my life's cause. But I am also not naive to think that there are times when there is an actor or group of actors so harmful that they can only be stopped because they are stopped. And if we find ourselves in that situation in the world, we have to make sure that how we stop the bad actors from harming millions of innocent people is done in a way that is as legitimate, as fair, and as pure for the global aim of peace as it can be. So there's the what to do, and there's the how to do it, and there's the who does it. But on the what to do, there are times when people have to stand up for other people in order to protect them and save their lives.
So just in this case, I'm wondering how effective you think international law has been. How effective have actors been in marshaling the tools of international law to, if not restrain Russia, at least isolate or establish a kind of taboo upon engaging with Russia? And I ask this because it often seems that powerful actors in the international order choose at their will when they want to abide by international law. And that's sort of how the game works. Powerful players say, you know what, I'll sign this treaty or I won't sign that statute. And certainly when it comes to supreme national interest, I think I'm going to opt out. How has the system worked up to now?
So I will take on the big nation. I think that the challenge in this circumstance is that it's Russia. It's that simple. But the reason why it's that simple is historical. So if we go back once again to World War II days, we have our own US President Roosevelt, FDR, we have Stalin, and we have Churchill. And they are three men negotiating the post-world structure and order of things during the war itself, saying, if we win, here's how we're going to set it up. And for anyone who's read biographies, historical records, there were some major disagreements between those three, let alone the national mechanisms behind them. And at the end of the day, if you look at the story from Stalin's perspective, and if you look at the story from what the Russian people were told from Stalin's perspective, there is a lot of reason to be angry at the way things turned out, and to be angry at the United States in particular about the way we handled things. And from there, I think we're seeing, several generations removed, the legacy of some of that anger that Putin himself holds, and who knows who else. In other words, this isn't just about what it seems to be about. This standoff and invasion that has Ukrainian people suffering at the middle of it is a bigger question around the world order of things, the values and the governance structures that should prevail. So I have been listening, and I had a chance to hear from our Ukrainian ambassador to the US 2 weeks ago in Washington, D.C., and people keep saying, this isn't just about Ukraine. And I would agree, it's about a lot more. So I think that in this circumstance, it's not just international law that has succeeded or failed. It's back to us, the people, who are using the tool of international law and a lot of other tools. What's the world order that we need? What's the world order that we can collectively agree to build? If the Russian people could negotiate for themselves with other people of the world and get back to collective norms and values of something we all agree on, what could be possible there? So that is a project that far extends international law, but the international law will be critical in playing a role in.
Right. So on that aspirational note, I want to ask you a final question at some level that kind of tests your faith in the whole proposition. Because there are some, and I'm thinking most recently of the scholar Sam Moyn, who's actually been on this podcast, came out with yet another book called Humane, that really questions whether our concern with things like the ethics of war, whether some weapons are legal and others are not, or whether or not we attend to sort of laws around torture and treating enemy combatants, whether that's sort of tinkering around the edges. And rather, what we should be doing is focusing our attention on banning war. Right? That's the sort of the must be the focus of our efforts. And I'm wondering, as someone who has operated really at the boundary between the theory and practice of international law, who's sort of both thought seriously about the theory of international law, but also engaged in its practice, how do you see this kind of critique of the international legal system?
It's a great question, and I appreciate Professor Moyn's work. He's a colleague of mine. I'm looking at my bookcase, and I'm looking at all the books about war and peace. And there's Mary Duziak, there's Rudy Tutel, there's Mary Ellen O'Connell. There's so many different people who've had critiques and thoughts about this very question. And one book I want to pull out for readers is called The Puzzle of Peace. And it's perhaps one of the most important recent database studies of not war, but of peace, and under the conditions in which peace prevails. And a quote from that book, which I always remember, is this, that peace is a relationship, war is an event. So I would say that not only is Professor Moyn's turn right, we need to go even deeper and further. We need to reprioritize, we need to invest, we need to take seriously the project of peace for our world. And in light of the future that we're facing as one species on this planet of many other species, the climate crisis and more, it's only through a deep, firm commitment to creating the conditions in which peace becomes possible that all of us are going to survive and thrive. So the project of peace is something that many people in World War II came to deeply care about and espouse. And I think it's time for our generations, all of us, to take that mantle up again. It's something I've committed my life's work to and believe deeply in, and it's work worth doing. So thank you for that question, and it's been a delight to join you, David, and be on today's podcast.
Well, thank you so much. This has been a most stimulating hour. I want to express my thanks to my colleague and friend, Professor Anna Spain Bradley, for making time out of her busy schedule. Great to be with you.
Great to be with you.
Thank you for listening to Then and Now, a podcast by the UCLA Luskin Center for History and Policy. You can learn more about our work or share your thoughts with us at our website, luskincenter.history.ucla.edu. Our show is produced by David Myers and Maya Ferdman, with original music by Daniel Reichman. Special thanks to the UCLA History Department for its support, and thanks to you for listening.